When every single one of your colleagues rejects your legal reasoning, it could highlight a fundamental problem with your framework. And right now, it's a clear signal that Ketanji Brown Jackson may need to reconsider her approach. In an 8-1 decision, the court ruled that Colorado's 2019 conversion therapy ban is unconstitutional as applied to Kaylee Chiles, a therapist who sought a preliminary injunction. Now, before I go further, what Colorado calls conversion therapy is not what you're probably picturing. Conversion therapy brings to mind like a dark room and kids being tied down to electrocute the gay out of them. While Colorado's law does ban that, despite nobody practicing that anymore, it goes further than that. Under Colorado's law, a therapist couldn't tell a gender dysphoric boy that he is a boy, while allowing them to tell that same boy that he is actually a girl. And that's where the issue lies. The court, in an opinion written by Gorsuch, held that the law unconstitutionally discriminates based on viewpoint, meaning that you can't specifically allow a therapist to affirm a kid's gender identity while banning any discussion that could lead to the child changing his mind. Which, yeah, makes sense. But Ketanji Brown Jackson decided that there exists a special category of speech called professional speech, where states can force medical personnel to tout specific viewpoints. She admits that the law discriminates based on viewpoint, but claims a carve-out exists to enforce medical standards of care. She, and Colorado's defense team, cited the 2018 case NIFLA v. Becerra and the historical practices like medical licensing, informed consent laws, and even the existence of medical malpractice claims to support her argument. Gorsuch dismantled each and every one of her arguments easily. First up, the NIFLA case. As Gorsuch noted, the NIFLA case specifically rejected a broad professional speech category with lesser constitutional protections, the one that Jackson claims exists. Professional speech gets the same safeguards as ordinary speech. But what about Jackson's other arguments? Each one of them tries to invoke history and tradition to claim a long pedigree of regulating medical speech. And we know that this Supreme Court cares about history and tradition, so let's go through each of them one by one. First up, medical licensing. Jackson argues that because medical licensing exists, states can regulate practitioners' speech. As Gorsuch points out, the first state license to be a counselor didn't exist until 1976. That's far too recent to be a part of this nation's history and tradition. Jackson tries claiming that since doctors have long needed state licenses, everyone in medicine bends to whatever whims the state demands. But here's the problem. Counselors are different. They don't operate on people, they don't prescribe medicine, and they didn't exist at any time near our nation's founding. Even after they appeared, licensing didn't hit until 76. More importantly, licenses have nothing to do with speech. They're about qualifications. Did you complete the relevant coursework? Did you log enough supervised hours? Did you pass the standardized tests? That's a far cry from telling you, say this, not that. So her licensing argument falls apart. Next up, informed consent laws. Yes, informed consent laws are real and constitutional. Yes, informed consent laws dictate speech. Doctors must disclose the factual risks of procedures. But here's the key. Informed consent laws are tied to physical acts, like surgery, that become an assault without consent. If you operate on someone without telling them, it's assault. If you say you're removing a skin tag but then take out their appendix, that's assault. Informed consent warns what you will physically do to someone before you do it. Again, that's a far cry from banning a therapist from telling a boy that he's a boy. Third, Jackson argues that because malpractice claims require a breach of a standard of care, that states can impose that standard of care, even if it regulates speech. This is probably her best argument, but Colorado's law still falls apart. In a malpractice claim, the patient must prove that an injury resulted from the doctor's breach of duty. But Colorado's law doesn't prescribe a standard of care or require injury. It punishes therapists immediately for certain speech. The moment you tell a boy he's not a girl, you could be fined, put on probation, or lose your license. There is no need to prove that any harm was done. So no, malpractice claims don't save Jackson's case. So all of Jackson's main arguments fall apart pretty easily. And the concurrence, written by Obama appointee Elena Kagan, makes clear why the law failed as applied. It was viewpoint-based. The law said it's okay to affirm a kid's gender identity, but it's not okay to ask questions that might make them question themselves. Kagan notes that if the law were rewritten as content-based instead, it might survive. Think of a law that bans both affirming and denying a kid's gender identity. Would that sort of law be helpful? I certainly don't think so, but something like that doesn't discriminate based on viewpoint, and therefore may be constitutional. The most problematic part of Jackson's dissent came at the end. She launches into a long rant, not about the law or the Constitution, but about how the majority doesn't care about medicine and how the field will fall apart. It's not grounded in the Constitution at all. The court often uses this slippery slope argument to argue for or against the law. The idea is that if you strike down a law, it might lead to a slippery slope where future courts let far worse things slide by unchallenged. But slippery slope analysis should focus on downstream legal effects, not real-world policy prescriptions. That policy stuff belongs to legislators, not Supreme Court justices. Jackson's focus on real-world policy effects, rather than legal effects, shows that her goal is to legislate from the bench. That's the exact opposite of what she should be doing. But as you'll see in today's online discussion from many on the left, it's exactly what they want from their Supreme Court justices. Subscribe and like the video for more from me. I'm trying to build a brand based on honest, reasonable takes and not the performative outrage you see from so many online these days. If that resonates with you, subscribe for me and head to my Substack to get new releases emailed directly to you. With that, I'll see you next time. Thank you.